Welcome to Chat with the Lawyer. I'm your host, Walla Blagay, and today we're honored to have Mr. Richard Condit from Mehri Skalet, a civil rights law firm in D.C., well known, and we're honored to have him here. He is going to tell us about a very important topic, whistleblower protection. This is something that many people want to know about. Who are whistleblowers? How do you become one? How are you protected by the law? And he's going to run us through all of the rules. Welcome.
Well, thank you. Great to be here.
So tell us how you got into the practice of whistleblowers and employment law.
Well, I went to a very progressive law school in Washington, D.C., the Antioch School of Law, which is now the David A. Clark School of Law at UDC. And during my time there, I was involved in an external clinic with an organization called the Government Accountability Project. And through GAP, I learned all about this whistleblower stuff, which I had never heard of before, and got very, very involved in it. And I've been practicing and working on whistleblower issues ever since.
Oh, interesting. So let's start, how does someone become a whistleblower? A lot of people feel like they can complain to their managers and all of a sudden they're a whistleblower. What are the rules?
Well, the rules vary really depending on what law you're involved in. So there are about 30 federal laws, probably more than that, but there are about 30 laws that I can think of off the top of my head right now that have some form of employee or whistleblower protection provision. And typically the way these provisions work is the whistleblower is protected for making a disclosure that is encouraged by that statute. So for example, in the context of the environment, there are several major federal environmental statutes like the Clean Air Act, the Clean Water Act. Each of them has an employee or whistleblower protection provision, and in order to be covered by those particular provisions, you would have to be, as an employee, raising a concern that was associated with the issues covered by those acts. So typically it's the subject matter of the acts that indicate what type of protection and how you would be protected as an employee.
Interesting. So what about just in general health and safety issues? What law protects that?
Well, in terms of just general occupational health and safety, there's the Occupational Safety and Health Act, which does have an employee protection provision. It's a little different than some of the other provisions, though, because when you file a complaint with OSHA saying that you've been retaliated against for raising an occupational safety concern, OSHA makes the determination of whether or not to litigate that claim. It becomes basically your lawyer or representative. And in many of the other statutes, like those that I mentioned a moment ago and others, basically the employee and their attorney, or his or her attorney, initiates the action and moves the action forward.
And when someone is being sort of retaliated against, could you give us examples of what that entails? Oh,
sure. So the most obvious example is when someone is terminated, right? So that's a pretty classic example of a situation where a person comes forward, or maybe they share information with the government or a regulator, and they make a disclosure, management doesn't like it, management finds a reason to fire them. And of course there is always a so-called legitimate reason for the firing, but we find when we get into it that often they're not very legitimate. And so what can happen from there is, depending on what statute is involved, the employee has to be aware of a statute of limitations. In some cases, like the employee protection provisions for the environmental statutes I mentioned a moment ago, there's only a 30-day statute of limitations period, which is very short.
Something in
30 days, yes. Most of them, though, are at least 180 days nowadays. So those few in the environmental statutes are unusual. So you have to be very mindful of that, and then you have to work with a lawyer who knows a little bit of something about these areas, because it's not typical employment law. There are some wrinkles associated with being a whistleblower lawyer that it's not the same as being a traditional labor lawyer.
And what is that?
Well, usually one of them is that in traditional labor law, you deal with things like the right to unionize or collectively bargain, or you may deal with things like race or sex discrimination, things of that nature. And those areas of law and through the EEOC and other things have been fairly well mapped out. In the whistleblower context, as I was mentioning a minute ago, the laws are really patchwork. So some industries are covered, some other industries are not. It really depends on the subject area, and so you need lawyers who are familiar with those subject areas and can navigate whatever the process is to bring a case successfully forward.
So someone has been terminated, they come to you. What are the next steps? What do you as a lawyer, when do you choose whether to take the case forward?
Well, it depends on what kind of case it is. So there's sort of two areas of whistleblower protection that we have in this country. One is the protection against retaliation that I was mentioning a few moments ago. But the other is circumstances where the law recognizes that if whistleblowers bring forth an important issue that results in the government recovering money of some kind, or initiating a penalty or civil fine of some nature, then they may be entitled to some percentage of that recovery.
Wow.
So if it's a retaliation issue, I would look closely at the employee's job record, whether they had any other instances of problems on the job. I would want to understand what the nature of the work environment was when they were terminated or action was taken against them that they're challenging. Had they had any other problems with this particular manager or supervisor before? What kinds of issues had they been raising? A lot of times people don't realize that they're being thought of as whistleblowers because they're just doing their jobs. I can't tell you how many people in all industries that I've worked with have said, well, Richard, I wasn't blowing the whistle, I was just doing my job. And that turns into a situation where they get in hot water with their management and they end up needing to figure out if they have any legal rights to contest what's happened to them.
Now, I hear a lot of times that whistleblowers often blow the whistle. They save, the society from whatever harm, but they're never actually saved themselves. Is that true? Or what's the...
Well, it's actually a very good point. In the practical reality is that being a whistleblower is an incredibly difficult position to be in. And there are a lot of reasons for that. One of them is that in our society and in most workplaces, whether it's a public employee workplace or a private sector workplace, there's a fairly high premium placed on loyalty, right? So when you're working on it with a team or you're working with within a certain structure, those folks are expecting you to stay loyal to the cause. When you break away from that and you find for the reasons of your conscience or because you feel like something unlawful is happening or other things, that you have to step out of that fold and create problems, then you are ostracized. You will have a very difficult time getting another job if you were fired, because the word on the street is going to be that you're not somebody that's reliable, right? That's not loyal, not somebody who you can count on. And so whistleblowers pay typically a fairly heavy price, even if they're successful down the road. It usually means that their careers are substantially altered or ended, depending on the severity of the issues that they were raising.
Now we talked about the law and sort of behind it, but let's put a picture behind this. What are people blowing whistles? The cases that you have or that you've had in the past, what type of information are they blowing and what's happening?
Well, there's a lot of different contexts because we have protection in different industries. So for example, I've worked on cases in the nuclear industry, and these involve commercial nuclear power plants, where there were employees that were raising concerns that the plant wasn't constructed correctly. So there were welds that were deficient, or they were using deficient steel or deficient other materials. Similar in the nuclear industry, I've worked with employees who are raising concerns that the company or the nuclear power facility was not adhering to quality assurance and quality control standards. As you might imagine, for a nuclear power plant, there's a lot of double, triple, quadruple processes that are in place to prevent an accident, because an accident would be a disaster. And if folks are not following the rules and if they're shortcutting the rules, then employees who take that seriously are going to be concerned. And if they're not getting adequate attention within the company to address it, they're going to bring it outside because they're going to be very concerned about it. So that's the nuclear arena. Worked with some folks in the financial industry who were some of the folks who tried to blow the whistle on the impending financial crisis, who were in their various banks or other institutions saying, I'm looking at this information about loans and other things, and I'm seeing fraud. I'm seeing problems with the percentage and riskiness or the percentage of risky loans that we're taking on here. We're not supposed to do that. That's not consistent with our policy. It's not consistent with other standards that we're saying we adhere to. Why are we doing this? And of course, they were subsequently terminated, or other things happened to them to take them out of those jobs, because at that time, those companies did not want to stop the gravy train. And we saw what happened because of that, which was a disaster for our country and the world, really.
Right, right.
So whistleblowers, I view whistleblowers in the experiences I've had with them as really a type of safety net for democracy,
right.
A safety net for law enforcement. They're like folks that are out there that they're the canary in the coal mine. They're the folks that can keep us out of serious trouble if we only listen to them and support them.
Now, going into another phase, the damages. Now, this person has gone out, done the right thing. They're suffering the consequences. There's got to be damages in this that they gain. So what type of money are we looking at? What happens in this?
Well, part of it is, let's separate the two types of cases out, first of all. So, I talked to you a little bit about there are these cases where there's a recovery based on if the government is paid back, or there are penalties or things. So we'll put those aside for a second. Let's talk about the straight retaliation case.
Because that's the most typical.
That's going to be more typical, is a situation where somebody's tried to do the right thing internally, or even taken a stance by providing information to the government or other regulator, and then they've run into trouble. So they're retaliated against, they're terminated, and then the question is, okay, what can happen there? Well, one of the standard damages is back pay, and it's usually back pay with some type of interest associated with the time that they have not been collecting a salary. In most of the statutes that we work with, they can get compensatory damages, which usually can be used to address things like pain and suffering, expenses for moving if you had to move to get a new job, other things that you can tie directly to the action that was taken against you. So it's not just every expense that happened to you once the job was gone, but it has to be tied to the actual fact that you were terminated improperly. So the compensatory damage realm can cover you in a lot of different areas. There are only a few statutes, unfortunately, that consider punitive damages as an option, unless you go under a common law remedy that might be available in your state, where the state recognizes punitive damages. But under the statutes, the federal statutes I'm talking about, there are a few that recognize punitive damages, and several of them have caps on punitive damages of not more than, say, $250,000 or something like that.
Well, that's great. Now, we're going to talk about this more when we get back. We're going to take a short break. This has been really helpful information. If you are a whistleblower, listen in, understand what you're going to do before you do it. Stay with us. We'll be right back.
I've never been the type to ask for help, but I had enough.
Thank you for calling the Veterans Crisis Line. How can I help you?
Life still has its challenges, but my family and I can deal with them better now. Veterans Crisis Line. It's your call.
Welcome back to Chat with the Lawyer, and I'm here with Mr. Richard Condit, and we are talking about whistleblower protection. And we're going to go back into the issue of punitive damages. Now, many people understand punitive damages. That's where the lottery comes in. The money falls. You get $5 million, and and you're saying that that's not in every case.
No, not in every case, for one reason, because many of these rights are based in statute. The employees can only get what the statute or the law allows, and in many instances, punitive damages are not part of it. And as I mentioned, in a few of the instances in federal whistleblower law where punitive damages are available, they are capped at something like $250,000 or something like that. Now, that doesn't mean that an employee may not have a more traditional civil tort type of claim in their state court where they might be able to get punitive damages, in which case the traditional punitive damage analysis would come into play. But what people need to understand about punitive damages, if they are available, is that it really requires a very specific level of proof of wanton, willful abusive. It's a very high level of proof, and courts are very inclined to entertain motions to either dismiss punitive damage claims or reduce them significantly if that level of evidence is not there. So people need to understand that it's not an automatic, just because there's a tough situation that you've been in, it's not automatic that you would get punitive damages.
Interesting. Now, let's go into what if somebody is wanting to blow a whistle. They're sitting at their desk, they're tired of what they're seeing, they think it might be safety issues impacted, they want to just do the right thing. Should they call a lawyer? What are the things they should be thinking about?
Well, I mean, it's always a tough situation when a person has come to that point where they're sort of breaking ranks with their colleagues or with their company or with whatever circumstances they find themselves in. And I guess I would say that not to over-lawyer things because I don't believe in that, but I do think that because it's such an important decision and because it may affect a person's career and their livelihood, it's probably a really good idea to get advice before you take the step. Now I know some people, or for a lot of people, these things sort of unfold in sequence or time that they don't really take the time to think about it. It's just happened, and so they're in a meeting or they suddenly feel compelled because of what's just happened that they need to say something and do something, and they go and do it. Try to resist that temptation. Try to get some counseling before you do that, because you want to understand, first of all, if you're even in dealing with an issue that's protected, because not all issues are protected.
True.
So you may be blowing the whistle on something that seems completely righteous, but it may not be covered under either federal or state law, and in which case, if action is taken against you for that, you may not have a remedy. So that would be a terrible shame if that was the case.
Interesting. And what about how much proof do you need? Now, some people can say, I've seen a case where somebody complained about something, and all of a sudden they were let go. And the employer said, it was because you just weren't doing good work there. So how much proof do you need from them about retaliation, about what's really retaliation?
Well, it's always good to have any kind of documentation that they might have been able to maintain. And let me drop a footnote about documentation, though. In talking about documentation, I'm not encouraging people to take information that they might not otherwise be entitled to. So we have, unfortunately, a number of situations we've seen over the years where an employee, in a totally righteous way, has taken a lot of information from the company, thinking that that's what they needed to prove their point, and only to find out that they had gone so far overboard that the court was not going to protect them for taking that information. So with respect to information, it is good for people to make notes of what kinds of records exist, where those records are maintained. Is it on the J drive on the server, or how is that handled? And then if they have information that's relevant to their own personal situation, such as personnel records, they've been given a reprimand or they've been given a termination notice, anything of that nature, then of course they'll want to bring that, and I'll want to see that. If they have evaluations, it's really important to see what their record has been leading up to this moment. If they've had a checkered history leading up to that moment, then it becomes potentially more believable that the employer has taken a legitimate action against them. It's not a guarantee, but we have to evaluate all of that type of information in order to properly assess and inform the client of what their chances are and what the circumstances are that they may face if they go forward.
So another thing to think about, what if somebody just wants to call the newspaper? They're like, I am so tired of it. I am willing to go down as a whistleblower and fire if I call Washington Post and just unleash the devil. What happens?
Well, there are folks that have done that. I mean, and certainly we know historically the story of Daniel Ellsberg.
Can you talk about Daniel Ellsberg?
Well, Daniel Ellsberg, released the Pentagon the Pentagon papers that were involved in uncovering the untruths about the Vietnam War, and he was in a quandary about how to do it, whether to do it, what to do, and ultimately decided that the New York Times was the best route to go in. That brought him under all kinds of scrutiny in terms of potential criminal charges and a whole host of things. And so, if you're working for the government or you're a government contractor, employee, or something like that, you have to be very careful about the type of information that you're sharing, even with the media or anyone. If you're in the private sector and not government involved, you still have to be very, very mindful of whether or not you're taking proprietary information, trade secret information. What are you about to tell the press that is going to make this story so sensational? And if it involves that type of information that I've just described, you really need to get legal advice before you do that, because once you've done it, the toothpaste is out of the tube, as they say, and there's no coming back.
Well, and also another person that comes to mind is Edward Snowden. We talked about this during the break. While there's another person that unleashed the documents to the public, got it to the press, and now he's not even in the country.
Right. Well, the Edward Snowden case is very interesting because I think his situation created such a national, brought such national attention to the idea of whistleblowing and what does it mean and what's legitimate whistleblowing, or what does it mean, is someone being a traitor if they're engaging in this kind of activity. And so I think many of us, whether you like what Edward Snowden did or not, I think folks have to be thankful to him at least for creating the circumstances of the dialogue, the circumstances of evaluating these issues of intrusion on our privacy, many, many things we would not know if it weren't for Edward Snowden and the folks that, that supported and worked with him. And so, if you're in an Edward Snowden kind of situation, if you're doing work in the intelligence field, for example, as a contractor to the government or as a government employee, you know very well that you have to be extremely careful about what you do and whether you share information or not. And the folks that preceded Edward Snowden, such as Thomas Drake.
And can you tell us about Thomas Drake?
Thomas Drake, Bill Wiebe, and some others, yeah, they were folks that were, in the national security apparatus who, were attempting to blow the whistle on the use of surveillance software and security systems that, they felt were basically unconstitutional. And they took very seriously the oath to uphold the Constitution. And so they found themselves in quite a predicament where, they're being charged, or at least Thomas Drake was being charged under the Espionage Act for, trying to advance those issues and even having a small dialogue with a reporter that didn't involve any release of national security information. But, his life was made a hell for a while until the government eventually had to back off from his prosecution because as the facts were beginning to unfold, the government knew that it couldn't prove a case against him. But yet, he for years was under the threat of a potential 30-year jail sentence. So involvement in national security matters, whether it's as a contractor or as a government employee, is a particularly dangerous arena, and where I would really urge folks, if you're in that place, you absolutely need to get legal counsel before you take even the smallest step.
I see. And what are government versus private? Who is better off as a whistleblower?
Well, it depends. In the federal government, for example, the federal government statute that provides whistleblower protection for federal government employees has actually been one of the guiding statutes for the establishment of certain rights in the private sector. And so as that statute has been improved over the years, then improvements have been made to the private sector statute. So we have the advocates for public employees to thank for some of the great protections we have in the private sector nowadays. So I would say, in terms of the question of who's better protected, if you're in an industry that has a statute that is like or very similar to the federal employee statute, then you are in pretty good shape in terms of whistleblower protection. If you are in other industries that either don't have protection or have weaker laws, then it's a different situation. And again, that's another reason to consult a lawyer so that you know what your rights and what the strength of those rights might be.
Now, and I know it seems like small issues, but I've run into it where people decide, okay, I'm going to blow the whistle. I'm going to come out. I'm going to start recording meetings, right. Secretly recording meetings. What is your say on that?
Well, on the one hand, we as lawyers often get excited when we hear, oh, and I recorded that meeting, and there's a recording of what he or she said, because, gosh, you can't really get around that proof, right? You avoid the he said, she said.
Right.
On the other hand, you really have to be mindful, the person really has to be mindful of what the rules of the organization are. For example, in certain parts of the government, it might even be illegal to record like that. In the private sector, depending on what the policies of that particular company are, and depending on what the state law is. Some state laws go so far as to say, you know, you can't unilaterally record other people. You have to give them notice. And if you unilaterally record them without them having notice, then you might be guilty of a crime.
Which is in the state of Maryland.
Yeah, and there's, I think, Massachusetts, and there's some other states that have similar types of provisions. So it's a very tempting thing to do. I get it, and you know, and as a lawyer, like I said, I'd be kind of excited for that information. But on the other hand, before you do it, you really do need to talk to somebody, talk to a lawyer who knows something about that area, and get some solid legal advice before you go that far.
Now, is there one case that got to your heart that you won or lost that you feel that you can discuss of how the outcome and what happened?
Well, there have been a lot of them. You know, I've been really fortunate. I think one of the great things about having chosen this area of law is that I've had the opportunity to work with so many terrific people. I mean, win or lose, they are just class acts and, you know, wonderful human beings. And what I want to tell people too is, you know, the whistleblowing sometimes gets a very kind of negative, you know, feedback. People think a whistleblower, oh, disloyal, rat, you know, somebody, you know, they're really not like that. That's not, their first choice is not to, you know, blow up the company or, you know, do things that expose their colleagues to you know, investigations or other things. They don't want to do that at all. They're just trying to do the right thing based on their conscience, based on, you know, what the circumstances are in front of them. And so, you know, I've worked with people in environmental examples, for example, where, you know, they were blowing the whistle on how a hazardous waste facility was operating. And, you know, there was one in Rock Hill, South Carolina, for example, that we worked on some years ago, and the waste handler there was saying, look, we're dumping all these wastes into our system when we're not supposed to. We're doing it at night, and you know, I can't keep doing this. You know, and he was trying to make the point, and he kind of gently tried to make the point within this company. You know, long story short, you know, obviously he ended up on the outs, but there was a church right nearby. The folks in the church were being affected. You know, they couldn't even hold their Easter egg hunts outside, you know, in the springtime because the odor and other things were so terrible. And eventually he lost, sadly, his whistleblower case because the retaliation law for that particular area was not very strong for whistleblowers. But his raising these issues, along with others who then supported him and raised them further, ended up in getting the facility shut down.
That is a great story.
So it was a tremendous success. Sad for him that he could not recover something for losing his job, but it was overall, in terms of the community, a wonderful story.
Now, if somebody wanted to contact you, how do they get in contact with you?
Well, we have a website like most firms do nowadays, and we're at findjustice.com, but we do have a special whistleblower website, which is fightfraudfindjustice.com, and on that website you can learn about some of the statutes and things that I've been talking about today, and you can also contact us through the website, from which we can do an intake. But a lot of people find that to be impersonal, and they're a little concerned about sharing information over the internet or over our website, and I respect that. And so you're welcome to just call our office directly, 202-822-5100, and someone will help you and put you in touch with me or others that can help you out.
Well, thank you for coming on our show.
It's been a great pleasure.
Mr. Condit, this was really good information. If you want to know more information, you can go to our website at www.chatwiththelawyer.tv. And please stay with us and watch more of our shows. Thank you.